The Law Society of Kenya, LSK, led by its president Eric Theuri, has disagreed with President William Ruto's proposal that the office of the Leader of Opposition be included in the Constitution and his activities funded by the government. According to Theuri, this is against the law, and if it is implemented, then it is appropriate to follow the legal procedures.
It is noted that the President further proposed that this amendment should be pursued without taking the Kenyan electorate through a referendum. As the Law Society of Kenya, we are outstanded by this move by the President, given that the amendments will affect the overall structure of Parliament and the Executive. The Constitution is very clear on the means of amending the Constitution with Article 255, providing the matters that require a referendum, and any amendment not related to matters mentioned in Article 255(1) are to be enacted by Parliament or by popular initiative. If an amendment touches on the national values,
Ruto has proposed the creation of the office of the official Leader of Opposition in order to cure what he says is the constitutional deficiency, full post-election destiny of the minority party,
and the principles of governance provided for in Article 10 of the Constitution, then they must go through a referendum. It is noted that the amendments as proposed by the President fall under the scope that require a referendum, and if pursued by way of the President's proposition, then the sovereignty of the people of Kenya would be undermined. In a democratic society that Kenya is, sovereignty starts with the people. If such amendments are to be initiated, then this should be through an amendment that is in tandem with the provisions of Article 255, 256, and 257 of the Constitution of Kenya.
In order to strengthen the management of the Parliament by executives, the President proposes the amendment of the standing rules of the Parliament to facilitate the participation of the secretaries, of ministers or chief administrative secretaries in the activities of Parliament and enable them to answer questions asked by the members of Parliament in their capacity as citizen representatives and in the implementation of their oversight responsibilities.
We also note that part of the amendments that the President proposes to deal with relate to gender. We are all aware that the President has made appointments of principal secretaries that do not comply with the Constitution. So as a Law Society, we are wondering if the President is an advocate of the gender parity principle, he should have started with appointment of the principal secretaries in a manner that is in compliance with the Constitution. And so therefore, it is a position of the Law Society that there are greater issues that are facing the country.
President wants members of the two parliaments lead the activity after the Supreme Court in the BBI case confirmed that the head of state does not have the authority to introduce changes to the Constitution.
The position of the CAS, the Chief Administrative Secretaries, is a matter that is under active litigation before the courts, and the Law Society of Kenya has in force orders stopping the establishment of that office, and that therefore the standing orders cannot be accommodated to accommodate a position that does not exist in law.
On 31st March 2022, Supreme Court judges said retired President Uhuru Kenyatta went against the law when he was leading the reforms of the Constitution. They said it should have been led by the people, not the president of the country sitting in power.
And we want to urge the president that there are greater issues that concern the executive other than the proposed unconstitutional amendments. We call on Parliament and all right-thinking Kenyans to resist the attempt to mutilate our Constitution, to change the basic structure of our Constitution to accommodate an office that is not in consonance with the presidential system of governance that this country gave itself when it adopted the 2010 Constitution. The Law Society calls upon the Speaker of the National Assembly to note that the proposed amendments are unconstitutional. The amendments are being initiated by the President contrary to the decision in the BBI case, and so therefore they should not see the light of day in Parliament, as there being a very clear precedent that has been set by the courts that those proposed amendments should not be entertained by Parliament.
For Ebro TV, Amode Francis.